The Supreme Court hasn't heard a Second Amendment case in more than a decade. Now that one's on the docket, legal experts and also advocates on both sides of the gun rights issue think this ruling could set the tone for gun control for decades to come.
And so that's really the question.
Glenn Smith is a constitutional law professor at California Western. He says the Supreme Court's upcoming Second Amendment case will be a landmark decision with long-lasting impact.
It's a perfect example of how we have this brief and general language in the Constitution that requires further interpretation and that can be very controversial.
The case before the Supreme Court is New York State Rifle and Pistol Association versus Bruen. At its core, it's about two people who had applications for concealed carry permits denied in New York. But the bigger question facing the court is if, quote, the Second Amendment allows the government to prohibit ordinary law-abiding citizens from carrying handguns outside the home for self-defense. New York requires people to show proper cause that they need protection when they apply, like a high-risk job or a restraining order against a violent person.
They can't just say, I have a general concern about public safety, or it's my right, as you said, to have a gun. They've got to show that they face some kind of specialized concern.
This case is definitely one San Diegans are going to want to watch.
Legal analyst Dan Eaton says this case could directly impact San Diego, because California has a similar rule. Here, county sheriffs must approve all concealed carry permits by deciding if the person applying has good cause to need one. If proper cause in New York is overturned, good cause in San Diego would likely follow.
The question in this case is what restrictions are reasonable and when do they go too far with respect to an individual's right to keep and bear concealed weapons outside the home.
San Diego has already been a battleground for these kinds of cases. San Diego District Court Judge Roger Benitez issued a handful of rulings against gun control laws in the state over the last 10 years. And in 2017, the San Diego case Peruta versus California challenged the state's good cause clause. That case reached the Supreme Court, but the justices declined to hear it. For this case, gun rights advocates in San Diego say proper cause is too vague and too restrictive. They hope this court, with newly appointed judges Brett Kavanaugh and Amy Coney Barrett, will strike it down and ease gun restrictions across the board.
Hopefully, the Supreme Court will see what a burden that is to sane, trained, law-abiding gun owners and strike it down, and that'll just disappear.
But people on the other side of the issue say restrictions like New York's and California's have a long history and should be difficult to overturn.
This is a very extreme argument being advanced that would result in more people carrying guns in more public spaces with no questions asked.
Smith and Eaton add the court could do three things: keep the rules in place, overturn them with a broad ruling that eases all gun control laws across the country, or issue a narrow ruling focusing just on the people in the Bruen case.
The bottom line is that this is the court's first real opportunity to issue a ruling on the merits about Second Amendment restrictions outside the homes.
People always just focus on who's going to win or lose, but it's really not. What's really going to be more important is how does someone win or lose.
Because this case could have huge ramifications, experts expect the judges to take their time in making their decision. We may not have a ruling on this one until this summer. Jared Aarons, ABC 10 News.